Good morning friends, Adab, Sasyakal, Namaskar. These are my videos in continuation with the Governor General Orders. This is my 124th video on this topic and it will talk of the applicability of the Governor General Orders in the regulation territory and a non-regulation territory. So how to counter, how to plead in the court. Now, Imperial Gazetteer of 1887 and 1902 at page 29 very clearly talks of regulation and non-regulation provinces. British India or the territory under the control of the Governor General in Council is divided into 8 large provinces and 5 lesser charges, each which is termed local governments. The 8 major provinces are the old presidencies of Madras, Bombay and Bengal. The 5 lieutenant governorships of Bengal, the United Province of Agra and Oudh, the Burma, Punjab, Eastern Bengal and Assam. Punjab, after its annexation, was governed by a board of administration and awarded by chief commissioners. After the mutiny in Delhi and those neighbouring countries were transferred to the northwestern province and it became a lieutenant governorship of 1859. This is how we compare the non-regulation territory and the regulation provinces, which is exhibited on page 33. The provinces was thus distinguished into regulation, non-regulation in accordance as they were originally administered under regulations framed under the Charter Acts or under the less formal code. The regulation provinces are called Bengal, Madras, Bombay and Agra. Now, how the GGO were given to in 1841 as to those areas which were not regulation territories. The East India Companies was originally managed in England by the Court of Directors and the General Court of Proprietors. The Regulation Act of 1773 did not interfere within the system but made some alterations in the voting. Warren Hastings convinced the nation that it was essential for the state to assume supervision of Indian affairs. There came the Pitt's Acts of 1784. It established a board of control which was gradually reduced and the board's power were virtually exercised by its president, the Lilian Perquisquer of the Secretary of State for India, that's the name given, who after 1841 was the sole member of the company, that's the East India Company. Now provinces, how are these areas? Regulation and non-regulations. So which are the areas? Madras, Bombay, Bengal and Agra are the 4 regulation territories. The principal non-regulation provinces are Punjab, Burma, Awadh and Central Province and Assam. Now where is it written? It's written on page 129, working only as agents to the Mughal emperor. Now it is very, I had said when the Diwani actually was being taken. On the assumption of a Diwani of Bengal of 1772, a series of instructions were promulgated on the basis of administration. But in making these, the company acted not under the authority of British Crown, but as agents of the Mughal emperor at Delhi. Regulation provinces were made for internal working. Now, Cornwallis Lord in 1793, one of them providing of the formation into a regular court of all those rules from time to time to be issued for the internal administration of Bengal. In 1797, another act confirmed this wise and salutary provisions and statutes passed in Madras in 1800 and for Madras and Bombay in 1807. So, how these 3 codes were coming up? Under this system, there grew up 3 codes known as those presidencies. and the company territories were administered until the year 1834. Charter Act 1773 was closed. By the Charter Act of what? 1833. The old series of the executive orders was closed and a new system was introduced in 1833. So we may call this Charter Act of 1833 as a Government of India Act 1833. Now this is a very important book which needs. Then finally came an Indian Council Act in 1861. What does it say on page 130? Passing the Indian Council Act, the Governor General in Council was empowered to extend the act to other parts of British India. So what was it doing till 1861? In pursuance of these provinces, subordinate legislative councils have been authorized for Bengal in 1862, United Province in 1886, for Punjab and Burma in 1898, for Eastern Bengal and Assam till 1905. So Governor General can alone pass ordinance, but these ordinances could only be promulgated or kept in abeyance till 6 months, like the present. So Governor General alone may, in case of pressing necessity, promulgate ordinances which are invested with same force and effect as an enactment of legislation, but it cannot remain in operation after 6 months if it has not been promulgated within its territorial states. So friends, this is very important. We can even read a book called Lord of Landlords and Tenants 1925, extension of enactments to cantonments as per section 25, page 167. The Governor General in Council by notification in the Gazette of India extend to all cantonments any enactment from time being in force in any municipality in British India, and modification if any as he thinks fit. So what are we again saying? Municipalities. Another book, House Owners and Tenants 1925, page 7, special notifications for implementation of various acts outside cantonments limit. Chapter 2 provides for the application of the act to any cantonment or part of a cantonment situated outside the limit of Presidency town. The local government concerned will issue the necessary notification under section 3 after local inquiry and the previous sanction of Governor General in Council. So now there is a word used called Presidency town. So are we following under the Presidency town, or the Presidency town is a local municipal area defined under various acts which we will talk later. So this is an area where then came the Cant Appendix, page 8, House Property Register, which I have just earlier talked to you. Then came the Governor General Council 59 dated 15th March 1835. Occupation of land for purposes unconnected with troops prohibited. So what are we all trying to say? What are we culminating ourselves to the 1836 order, which we are? Now the Governor General Order of 179, 12th September 1836. This is the Bible. It says all houses, this, military cantonments. We were on a Zoom session, somebody asked me all this. Not belonging to army, which may deemed by the commanding officer of the station suitable for their locality, for the accommodation of officers, shall be claimable for purchase or for hire at the option of the owner. It doesn't talk of grant or grantee. In the former case at a valuation and in a later at a rent. So under this GG also, the government has a right not to either resume. It can even take it on rent. But it has to be a fixed rent. So what is all happening is to be understood. If we go down, the committee is to be composed. One civil officer has to be there in principle. If practicable, or at a vicinity of the station, the commanding officer of the cantonment and an officer belonging to the station to be named. by the proprietor of the premises. Now the word proprietor has come here. It has not come as owners, and their decision whether relating to the terms of purchase or rent is to be conclusive, unless it shall be reserved for government for those orders the proprietors of the committees are submitted. When the house of the officer of one corp are to be transferred to those of another as an occasion of relief, if a difference of opinion should arise, as a fair terms of transfer, the price shall be fixed by the committee of arbitration. That means this grant was saleable from A officer to B officer. If the rates were not being fixed, so was this the reason why the sale deeds were culminating in these GGOs or these bungalows? If we read page 54, where private properties in Governor General Order 30th October 1832, Regulation 22, 1827, Section 21, Clause 1st and Government General Order 6 January 1827, Military Code, 2nd Supplement at page 27, Article 92, no private land property is to be included within the limits of cantonment, in which the whole of the ground belongs to government. The Right Honourable the Governor in Council is pleased to declare that the commanding officer have the powers of removing from cantonment and preventing the residence therein of any person not belonging to an officer or soldier belonging to the force, and that it is the duty of the commanding officer. So, laws were made that within military station or within cantonments, no private lands, and simultaneously the law was even saying that there could have been encroachments. So, well, let's try and remove this. So, you have to understand, it is not a hard and fast fixed rule that there could have been no private lands within the cantonment. Similarly, the GGO 260 of 7th May 1838, it clearly said the various orders now in force in this presidency in regards to the occupation of ground and the disposal of premises of buildings within the limits of military cantonment are rescinded, and the following regulations are substituted. So that means 1838 all GGOs were rescinded earlier to it. Again, private properties, military station, within the military boundary pillars, old roads, new roads cannot be opened. I've already explained to you all this. So, permission to occupy lands or ground in military cantonment confers no proprietary rights on the occupant. This is what finally the Britishers or the Governor General said. It continues the property of a state at a presumable pleasure of the government. What is this resumption actually? We need to all understand this. We have various orders which I have already talked in the earlier video, and then we had the Army Regulations of 1875, which again said 1855 and 1810 of the Bengal said that there has to be boundary pillars. Where are those limits? It talks of even bazaar shall be marked by the magistrate. Has the bazaar in Bombay Presidencies marked? Every plan had to be kept. Where are those plans? Okay, well, a new plan approved by the local magistrate and the commander-in-chief, finally given to the Government of India, and after approval, the old plan is finished and the new is to be kept. So, where are those plans? How do we get to know which boundaries are extended? Even today under section 4, any cantonment very clearly says it can add in, it can subtract in any boundaries of the cantonment. So, all this is very culminating. It becomes very difficult to explain at times and people don't understand. Read the Army Regulation of 1887, Volume 2, Part 2, Section 17, Cantonments. So that means cantonments had come then. It even came in 1855. The limits of cantonments or bazaar shall be marked by the local magistrate and political agents and marking out the limits of new cantonments, private property is not to be included therein. So that means we were not including private properties. So what were we trying to, how was the applicability of so many Governor General orders, whether for giving a grant, whether for maintaining the plans, whether for making sure that private properties are not a part of that Bombay Presidency or Bengal or Madras or the provinces under the non-regulation. How do we get to know those? Till that plan is not exhibited. Has anybody in its pleading till date exhibited their plans of the boundaries? We do not have of 18, if I talk of Ambala, we do not have the plan of 1877. We do not have the boundary pillars of 1889. We just have a plan from 1 to 36, then changed from 1977 when the civil area was excised. Everything done in 1877, 1902, we don't know. There are no reports of the local magistrate. So friends, please wake up. I can only say, please subscribe to my YouTube channel. These are very important. Then only you can understand why I admit and say that we are old grants. Thank you. Good day.